Good afternoon, everyone, and welcome to the Lead Center webinar on disability, employment, and Lane v. Brown. This is Rebecca Salon. I am the Lead Center Project Director at National Disability Institute. And at this time, I'd like to turn the mic over to my colleague, Nakia Matthews. She will review some housekeeping details so that you can all fully participate in the webinar. Nakia?
Thank you, Rebecca, and good afternoon, everyone. The audio for today's webinar is being broadcast through your computer. Please make sure that your speakers are turned on. You can control the audio broadcast via the audio broadcast panel. If you accidentally close this panel, you can reopen it by going to the Communicate menu at the top of your screen and choosing Audio Broadcast. If you do not have sound capabilities on your computer, or if you prefer to listen by phone, you can dial the toll or toll-free number you see here and enter the meeting code. Please note that you do not need to enter an attendee ID. Real-time captioning is provided during this webinar. The captions can be found in the Media Viewer panel, which appears in the lower right corner of the webinar platform. If you would like to make the Media Viewer panel larger, you can do so by minimizing some of the other panels like chat or Q&A, and conversely, if you do not need the captions, you can go ahead and minimize the Media Viewer panel. We will have time for questions during and at the end of the webinar. You can use the chat or the Q&A box to send us questions that you may have. You can send them to all of us or to me, Nakia Matthews. If you are listening by phone only and not logged into the web portion, you may also ask questions by emailing them to me directly at nmatthews@ndi-inc.org. Please note that this webinar is being recorded and that the materials and recording will be placed on the Lead Center website at the URL you see below. If you experience any technical difficulties during the webinar, please use the chat box to send me a message, or you may email me at nmatthews@ndi-inc.org. And with that, I'll turn it back over to Rebecca.
Thank you so much, Nakia. We're very excited to have so many people participating in this webinar. For those of you who are new to the Lead Center, we are the National Center on Leadership for the Employment and Economic Advancement of People with Disabilities. We're a collaborative of disability and workforce and economic empowerment organizations led by National Disability Institute with funding from the U.S. Department of Labor's Office of Disability Employment Policy. Our mission is to advance sustainable, individual, and systems-level change that results in improved competitive, integrated employment and economic self-sufficiency outcomes for individuals across the spectrum of disability. And we encourage you to visit the leadcenter.org website. There's a lot of information about our work in different parts of the country. We also wanted to draw your attention on the next slide to a new Employment First portion of the Lead Center website. It's at employmentfirst.leadcenter.org. It has very robust information about what's happening nationally and in each state regarding Employment First. And with that, I'd like to introduce our first speaker. Today's moderator is Serena Lowe, Senior Policy Advisor for Workforce Development at the U.S. Department of Labor's Office of Disability Employment Policy. Serena?
Thank you so much at the National Lead Center. Good afternoon, everyone. On behalf of the Office of Disability Employment Policy, I want to welcome you again to today's webinar entitled Olmstead, Employment, and Lane versus Brown. As many of you know, we live in a time of enormous change, whether it be in public policy reform, in the advancement of civil rights for individuals with disabilities, or in the massive systems change that we are seeing at the ground level within local regions and states throughout the country. We felt at ODAS as being the largest federal investor at this time of cross-systems change efforts reflective of an employment-first movement across the country, that it was really important to host a national webinar to afford those of you in the field who are leading systems change efforts, whether you be local or state political leaders, public policy officials, or providers of disability services, and most importantly, citizens with disabilities and their families, to really hear and learn about two most recent legal settlements in our nation's civil rights framework for how the American with Disabilities Act and specifically Title II and the Olmstead integration mandate applies to promoting competitive integrated employment options for individuals with disabilities. We have lined up today an amazing panel of individuals, which I have the privilege of introducing to you. I want to talk a little bit about the process that we're going to take today to try to make this as interactive and informative to you as a national audience as possible. We will be receiving comments and questions via the interactive chat feature that's available through this webinar. And our presenters, as they are able, will try to get to many of your questions in the context of their presentation. I will also try to infuse a couple of questions in between presentations, and then if time affords us, we will have other questions at the end of all of the presenters' discussions or speaking points. I think it's really important that we understand the significance of these underlying settlement agreements both in Rhode Island and now in Oregon, and their impact not only on our collective work in the area of public policy and systems change, but more importantly on citizens with disabilities and their rights to work in the general workforce, to be part of the economic mainstream, and to live as optimally independent and with as much socioeconomic advancement as possible. So with that, I'd like to go ahead and turn it to our first panel. We are joined today by four of the most brilliant civil rights lawyers of our time, frankly, and it's such a privilege to have all four of them as a team today. The team from the U.S. Department of Justice is going to be led by Eve Hill, who's the Deputy Assistant Attorney General for Civil Rights at U.S. DOJ, where she's a member of the Civil Rights Division's leadership team and is responsible for the oversight of the division's disability rights enforcement, educational civil rights enforcement interagency, coordination of civil rights laws, and the American Indian Working Group. Joining her is Sheila Foran, the Special Legal Counsel for U.S. Department of Justice, where she has over 20 years of experience in civil rights enforcement and has held a number of senior positions throughout the federal government. Max Labertoza is also joining the group. He is a trial attorney in the Housing and Civil Enforcement section of the Civil Rights Division of U.S. Department of Justice and litigates cases to enforce the Fair Housing Act, the Americans with Disabilities Act, Title II, the 1964 Civil Rights Act, and the Religious Land Use and Institutionalized Persons Act. And last but certainly not least on the DOJ docket is Regina Klein, who is a trial attorney with the Disability Rights section of the Civil Rights Division of the U.S. Department of Justice. And while at DOJ, Gina has focused on the integration mandate of the ADA, protecting the civil rights of individuals with disabilities to receive services in the community. I'm going to turn it over to our colleagues from the U.S. Department of Justice, and once they are done, they will be followed up by two separate presentations from leaders from the state of Oregon. So turning it over, Eve, to you and your team.
Thank you. Thank you, and thank you, Serena, for calling me brilliant. It's really the team that I'm here with today who are doing the brilliant work, but I enjoy being associated with them. We are thrilled to have the chance to speak to you today about the Justice Department's work on enforcement of the Supreme Court's Olmstead versus LC decision as it applies to employment and day service systems. We're also happy to be joined by some of the state and local partners from Oregon. I'm, as Serena said, a Deputy Assistant Attorney General in the Civil Rights Division at the Justice Department, and joined here today by Sheila Foran, Special Legal Counsel, Max Lipertosa, and Gina Klein, who are both trial attorneys. Together, we work across the division and with other federal agencies on a range of Americans with Disabilities Act enforcement issues related to community integration for individuals with disabilities. For what we're talking about today, this is a really exciting moment, a critical moment for integrated employment from the perspective of the Justice Department. Just today, in our own Department of Justice National Disability Employment Awareness Month event, I was reminded about a July 2015 Harris poll on Americans' understanding of intellectual disabilities, and that poll emphasized why integration is so important. According to that poll, people who know someone with an intellectual or developmental disability, and I will periodically refer to that as IDD, those people who know someone are 3 times more comfortable with and compassionate towards people with intellectual and developmental disabilities, and twice as likely to understand the truth about intellectual disabilities. So people become less prejudiced towards people with disabilities if they get to meet them and know them. But that poll showed that only a little more than 50% of Americans know anybody with an intellectual disability. And why is that? Where do you meet people? Very often we meet people at school and at work. So unless people with disabilities are included in our classes and our workplaces, we're not going to meet them, we're not going to become their friends, and we're going to continue to act on our own assumptions and prejudices about what disability really means. And the other thing the Harris poll showed, though, was that Americans are ready to meet, go to school, and work with people with intellectual and developmental disabilities. Americans overwhelmingly believe people with IDD can and should work. And 80% of us say we would be comfortable hiring someone with an intellectual or developmental disability. And 60% of us say kids with and without IDD should be in classes together. So the Department of Justice has, in recent years, been engaged in efforts to vigorously enforce the Supreme Court's decision in Olmstead. That ruling requires states to eliminate unnecessary segregation of people with disabilities and to move people who can and want to receive services in the community out of segregated settings. Olmstead enforcement has been a top priority for this administration and for the Department of Justice in particular. The Department's Olmstead enforcement work since 2009 has directly affected 53,000 individuals. Until 2011, though, the Olmstead litigation we did involved primarily unnecessary segregation of people with disabilities in residential institutions. Recent enforcement actions brought by the Department have challenged states' over-reliance on segregated employment and day service settings. Over the past few years, these enforcement actions have also been accompanied by broad policy changes that promote and expand the array of integrated employment and day service options available to individuals with disabilities across the country, and to reduce states' excessive reliance on segregated employment settings like sheltered workshops. The Department has advanced the rights of thousands of individuals with disabilities who've been unnecessarily segregated in sheltered workshops and facility-based day programs, or who've been placed at serious risk of unnecessary segregation. Specifically, we've done that through 3 cases in the last 3 years, which we'll discuss today. United States versus Rhode Island and the City of Providence in 2013, United States versus Rhode Island in 2014, and United States versus Oregon, also known as Lane versus Brown, in 2015. Each of these cases was brought under Title II of the ADA and the Supreme Court decision in Olmstead. Through these court-enforceable settlement agreements, these cases together will ensure approximately 10,500 individuals with intellectual and developmental disabilities will receive services and supports necessary for them to work in competitive, integrated employment and to participate in a range of integrated activities. So I'm now going to turn this over to Sheila Foran to discuss the legal principles that support these cases.
Thank you, Eve. Before launching into the specifics of the Rhode Island and Oregon agreements, as Eve said, we thought it important to quickly remind everybody of the basic legal framework that's the foundation for this work. I'm going to go through these next 10 slides kind of quickly, as many of you are already fully steeped in these concepts. But as Eve was really getting at, integration is a core value of the Americans with Disabilities Act. If you read the legislative history, the statutes, the regulations, it becomes clear that integration is actually the overarching theme of the ADA. And in fact, if you think about it, everything the ADA requires, curb cuts, accessible entrances, service animal admission, interpreters, all of these measures are intended to ensure that people with disabilities have access to the same opportunities to enjoy services, programs, and activities in the community that are available to those without disabilities, so that they can join the mainstream of American life. So Title II of the Americans with Disabilities Act prohibits discrimination against individuals with disabilities by public entities. The integration mandate regulation requires public entities to administer services, programs, and activities in the most integrated setting appropriate to the needs of qualified individuals with disabilities. And the definition of the most integrated setting is one that, quote, enables individuals with disabilities to interact with non-disabled persons to the fullest extent possible, end quote. So let's talk briefly about the Olmstead decision. In 1999, the Supreme Court was presented with the opportunity to apply the integration mandate in a case brought by two women with developmental disabilities who were challenging their unnecessary segregation in a residential institution owned and operated by the state. And the Supreme Court held that Title II of the ADA prohibits the unjustified segregation of individuals with disabilities. The language the court used to support its holding is powerful, to say the least. The court stated that this holding reflects two evident judgments. First, quote, institutional placement of persons who can handle and benefit from community settings perpetuates unwarranted assumptions that persons so isolated are incapable or unworthy of participating in community life, end quote. Second, quote, confinement in an institution severely diminishes the everyday life activities of individuals, including family relations, social contacts, work options, economic independence, educational advancement, and cultural enrichment, end quote. Importantly, the court also set forth a specific analytic framework. Under Olmstead, public entities are required to provide community-based services to persons with disabilities when A, such services are appropriate, B, the affected persons do not oppose community-based treatment, and C, community-based services can be reasonably accommodated. That means taking into account the resources available to the entity and the needs of others who are receiving disability services from the entity. So, when is the ADA's integration mandate implicated? Although Olmstead was decided in the context of a state-run facility, the integration mandate applies whenever government programs result in unjustified segregation, not only by operating facilities or programs that segregate people with disabilities, but by financing the segregation of people with disabilities in private placements, or by promoting segregation through planning, service design, funding choices, or practices. So who does the integration mandate cover? It's important to recognize the ADA and Olmstead, not limited to individuals already in institutions or other segregated settings. They also extend to people at risk, serious risk of institutionalization or segregation. Examples include people with urgent needs on wait lists for services, or people subject to cuts in community services, leading to the person's unnecessary institutionalization. It's important to note that the ADA and the integration mandate have a broad reach. Title II of the ADA covers all services, programs, and activities of all state and local government entities. So there's no question that employment and day services provided by the state are covered. The extension of the ADA and Olmstead to daytime employment services was confirmed by the court in the Oregon litigation, which we'll be referring to today as Lane v. Kitzhaber or Lane v. Brown. And in finding plaintiffs' claims valid under Title II of the ADA, the court stated that, quote, the broad language and remedial purposes of the ADA supported the conclusion that the integration mandate applied to employment services. And this was a new and important precedent supporting the Department's Olmstead enforcement efforts. And this is consistent with how DOJ has interpreted and applied the ADA and Olmstead over the years. In settlements in Virginia, in Delaware, in North Carolina, Georgia, all of these included in the required relief expansion of supported employment and integrated day activities, even though those services and programs were not the focus of those investigations. So far, the Department has advanced the civil rights of thousands of individuals with disabilities who've been unnecessarily segregated, and has done so through those three cases that Eve mentioned: Rhode Island v. the City of Providence, United States v. Rhode Island and the City of Providence, United States v. Rhode Island, United States v. Oregon. Let's turn to what do we mean by integrated employment. We're talking about individualized, typical jobs in the community, earning at least minimum wage, working among peers without disabilities for the maximum number of hours consistent with the person's abilities and preferences. What do we mean by integrated day services? We mean services that allow people with IDD to engage in self-controlled recreational, social, educational, cultural, and athletic activities, including community volunteer activities and training activities. After that crash course in the legal framework of the ADA, we're going to turn now to the specifics of the Rhode Island Agreement. Here's Tina Klein.
Thank you, Sheila. To describe U.S. v. Rhode Island and the City of Providence, which was a June 2013 agreement, the Department of Justice, the State of Rhode Island, and the City of Providence entered into this agreement that involves one of Rhode Island's largest sheltered workshops, training through placement, otherwise called TTP, and the high school-based sheltered workshop, the Birch School, which the Department of Justice found fed graduating students into the adult sheltered workshop as a virtual pipeline. For instance, in this past 26 years of that provider's, of that school's operations, only a handful of students ever transitioned into individual supported employment after leaving the in-school sheltered workshop at the Birch School. Under the court-enforceable agreement we negotiated resolving the case, individuals from TTP and Birch are receiving supported employment and integrated day services, and that school-to-sheltered workshop pipeline has been dismantled. The services provided under the agreement include robust person-centered planning, career development planning, youth transition services and supports, and of course, importantly, placements in competitive integrated employment and integrated day services. Today, individuals who spent decades at TTP, some sorting remote controls, others pickling and stuffing peppers in exchange for sub-minimum wages, are now working in competitive integrated employment in various integrated employment settings. Birch students are now receiving the services and supports necessary to introduce them to real work in competitive integrated settings prior to exit from school. In January 2014, the Civil Rights Division of Justice found that the state of Rhode Island violated the ADA and the Supreme Court's Olmstead decision by failing to serve people with IDD across the state in the most integrated setting appropriate. Subsequently, in April of 2014, the United States and Rhode Island entered into the first statewide settlement agreement that will provide relief to individuals with intellectual and developmental disabilities unnecessarily segregated in sheltered workshops. That agreement provided relief to approximately 3,250 people. It provided the individuals covered by the agreement with real employment in the community at competitive wages and integrated day activities during their non-work hours. In that case, U.S. v. Rhode Island, the Department of Justice found that approximately 80% of the people with IDD receiving state services in Rhode Island were placed in segregated sheltered workshops or facility-based day programs. And by contrast, only about 12%, that's 12%, actually participated in individualized integrated employment. The investigation found that the state of Rhode Island had over-relied on segregated service settings to the exclusion of integrated alternatives. And we just want to state, we also found that placement in segregated settings in Rhode Island was frequently permanent. Nearly half of the individuals in shelter workshops had been there for 10 years or more, and over a third had been there for 15 years or more. The average wage reportedly earned by the population was $2.21 per hour. We also found that the state of Rhode Island's data showed that among youth with IDD who transitioned out of Rhode Island secondary schools over a 2-year period from 2010 to 2012, only about 5% transitioned into jobs in integrated settings, even though many more of these students were able to work in integrated employment and not opposed to it. So what does the Rhode Island consent decree require? it requires that Rhode Island will transform its service system over the next 10 years, providing relief to those 3,250 people. Rhode Island will provide supported employment placements to approximately 2,000 individuals, and the agreement provides 1,250 youth between the ages of 14 and 21 with access to high-quality transition services, including instruction, community experiences, the development of employment and other post-school adult living objectives, school-based preparatory experiences, career preparation, integrated work-based learning experiences, site visits, job shadowing, soft skill and job skill development, internships. That's what students will have access to over the next 10 years in Rhode Island. The consent decree focuses squarely on youth in another area. The Rhode Island Department of Education has adopted an employment-first policy and is actively promoting, under the requirements of the agreement, a school-to-work transition planning process that includes timelines and benchmarks for all youth who are in transition with IDD ages 14 to 21. The consent decree provides that all persons receiving supported employment placements will also be provided with integrated non-work services, ensuring that individuals have access to integrated work and integration during their non-work hours. What we mean by integrated day services is the services and supports that are necessary to allow people with IDD to engage in self-directed activities in the community at times, frequencies, and with persons of their choosing, and to interact to the fullest extent possible with non-disabled peers. And we recognize so frequently that this decree, constitutes a sustained commitment over time. The sustained commitment comes with a commitment to fully fund the agreement. Every requirement in the agreement contains quality indicators, ways in which services will be measured and reported. It's not just funding this year, it's not just lip service to the idea of future funding, it's a requirement that the agreement is fully funded and for the term of the agreement. The agreement also has outreach, education, and support provisions. The state of Rhode Island is required to develop an outreach, in-reach, and education program that explains the benefits of supported employment and addresses families' concerns about participating in supported employment. To ensure informed choice, individuals with IDD may remain in segregated programs if they request a variance under the decree. And that variance will be granted if they have engaged in certain designated steps, which include the opportunity to make a meaningful choice about what employment really is. That includes a vocational assessment, a trial work experience in a competitive integrated setting, outreach information, and benefits counseling. Provider capacity is something that's designated in the agreement as a requirement and something that the Justice Department sees as a critical part of the success of the decree. The state of Rhode Island established a Sheltered Workshop Conversion Institute under the decree to assist qualified providers of shelter workshop services to convert their employment programs to accommodate an array of integrated service options. The state will establish and has established a Sheltered Workshop Conversion Trust Fund of $800,000 to assist with the upfront startup costs to providers that have agreed to convert their services from primarily sheltered employment to primarily supported employment services. 1 year into the U.S. v. Rhode Island consent decree, individuals who have spent decades in shelter workshops are now working in competitive integrated employment settings throughout Rhode Island. Person-centered planning and employment-first policies and practices exist across state agencies, and the Shelter Workshop Conversion Institute and Trust Fund is engaged actively in working with providers to assist them in this process of conversion and transformation. I'm now going to turn it over to my colleague, Max Lapertoso, to discuss what we've been calling Lane v. Kitzhaber, or in the alternative, Lane v. Brown, or US v. Oregon.
Thank you, everyone. I'm going to start today by discussing briefly the origins of the Department of Justice's involvement in Lane v. Brown and the filing of an intervention motion in that case, our investigative findings, in other words, what we found when we went to Oregon and started looking at some of its employment services, followed by a discussion of what the state did in response to our involvement, some of the measures the state took to increase employment services for people with intellectual disabilities, and then finally the settlement that we, the private plaintiffs, and the state reached last August, and which will be reviewed by the court on December 7th at a fairness hearing. Oregon, to me at least, is a fascinating case because it confronts head-on the question, what is integration, in a way that most of the cases that I've worked on or been exposed to have not. When we came to Oregon in 2012, Oregon had no residential institutions for people with intellectual disabilities. It was in a group of maybe 9 or 10 states at my last count who don't have any state-operated residential facilities and don't have any ICFs or intermediate care facilities. Everybody with an intellectual disability in Oregon is and was living in the community. And the question that our case confronted head-on was, is that integration? Does integration simply require that people be physically present in the community, or does it require something more than that? And the integration mandate of the ADA, as has been described earlier, doesn't say specifically close all institutions. What it says is that when a state provides services and programs for people with disabilities, it has to allow people the opportunity to interact with non-disabled people to the maximum extent appropriate. And so when we looked at the state's employment services, we were looking at whether that was the case. Because if it's simply about physically being in the community, then Oregon had clearly met that. If it was about being a part of the community, contributing to your community, and interacting with non-disabled people to the maximum extent appropriate, then it was important to look at the employment services that Oregon was providing to enable people to work, and whether that was allowing people to work in a real job with real wages, with non-disabled coworkers and real benefits, or whether they were just in segregated workshops where they had little to no opportunity to work with people without disabilities, where they were by and large not earning minimum wage or the wages that a non-disabled person would earn for similar work, and by and large not earning benefits. Because integration really happens at work, as Eve said earlier. And to me, that's what the settlement that we in the state reached is all about, and that's what this case has been all about. So when we went to Oregon in 2012, what we learned was that, no surprise, Oregon had started off as a very progressive state when it came to employment of people with intellectual disabilities. In the 1980s and early 1990s, Oregon had pioneered a number of models that at the time were very advanced. They pioneered the very idea that people with intellectual disabilities are capable of working, which was not widely accepted at the time. By 2012, however, the state had backtracked, particularly when it came to other states, when they were compared to other states. And so by the time we started our investigation, the vast majority of people with intellectual developmental disabilities were spending their days in segregated work settings. Less than 16% of people with intellectual disabilities were working in integrated, what we would all consider integrated employment. And when we looked at service hours, in other words, the number of hours that the state was paying for employment services, only 10% of those were happening in integrated employment settings. So clearly something needed to be done, and to a large extent the state recognized that something needed to be done about that. For youth as well, there were significant problems. There was a funnel of youth coming from schools into sheltered workshops because, by and large, there was no expectation that youth with intellectual disabilities were capable of entering the job market. That has changed in Oregon, but that was that was certainly one assumption. And then transition planning was not going on in public schools by and large. Obviously, there are exceptions to that, but by and large, people were not coming out of the school system to be trained to work in an integrated environment. So following our intervention in the case, which was in the spring of 2013, the state took a number of steps to develop a plan to expand integrated employment. The main initiative was an executive order that the governor of Oregon at the time, Governor Kitzhaber, signed that did a number of things that were not happening before. It required, for example, coordination between the three main state agencies that oversee employment. That's the State Office of Developmental Disability Services, the Office of Vocational Rehabilitation, and the State Department of Education. It began a number of initiatives around training, technical assistance, provider transformation, and provider capacity. It set up a policy group of stakeholders to advise the state and develop job metrics and goals to reach. It mandated new data collection and data measures, and that has changed considerably over the past 2 years in Oregon. It created an Employment First Office that reports directly to the Department of Human Services, and you'll hear from Mr. Maley later, who was the director of that office. It what we colloquially have called closed the front door of workshops, meaning it set a deadline for both prohibiting vocational assessments from going on in workshops and from prohibiting the DD agency and the VR agency from paying for any new placements in workshops. The assessment prohibition went into effect in July of 2014. The prohibition on new sheltered workshop placements went into effect in July 2015. And then finally, the executive order required employment services, not necessarily an outcome, but it required the provision of a service to 2,000 people, and then in 2015 that was expanded to 7,000 people. There were other documents such as an integrated employment plan which provided more detailed metrics. There was a quality assurance plan. There were numerous new policies and regulations coming in that were meant to codify a number of these initiatives. The state developed new CMS waivers that for the first time define these services versus just having just one broad day service definition. And there are new rates that are designed to incentivize supported employment for providers. And that is a work in process right now, and it's addressed to some extent in our settlement agreement. So last summer, after some robust discussions, we reached a settlement with the state that incorporates and recognizes a number of their efforts over the past 2 years, including the executive order and parts of their integrated employment plan, and puts them in a court-enforceable and binding agreement with some defenses to the state. It adds other substantive provisions that we think strengthen the state's ongoing efforts. I mentioned rates earlier, so one example is that when the state does develop new rates for providers, it will incentivize rates for providers who are able to find jobs for their clients at 20 hours a week or more. The main points of the settlement agreement is that there is a clear shift now from reliance on segregated employment towards a reliance on integrated employment. Under the agreement, 1,115 persons in workshops will transition into competitive employment over the next 7 years. That is about half of the amount of people in workshops as of 2015. It incorporates the executive order provision that there is no new funding for workshop placements after July 2015. Of the 7,000 people that will get employment services under the executive order, the agreement requires that 4,900 of them be youth in transition. In other words, youth coming out of schools entering the DD system for the first time. And of those, 50% have to get an individual plan of employment from vocational rehabilitation, which is a necessary prerequisite to getting a job in the community. The agreement requires that the workshop population be decreased from 2,717 people in 2014 to 1,530 people in 2017, or a 1,200 person decrease. And the state is on track on that right now. And the agreement requires that service hours in the workshops be decreased by around 27,000 hours over 3 years. The other principle of this agreement is that it ensures the ability of all individuals in the system to be able to choose integrated employment if that is what they desire. So every person in a workshop must be provided with a career development plan which will allow them to be exposed to information and choices about employment and also to choose or not choose employment. The services they're provided must be evidence-based, individualized, and flexible. They must maximize the number of hours a person is capable of working and wants to work. And again, their career development plans have to reflect these requirements. And finally, like residential services, employment services have to be driven by a person's abilities, not simply by whether services are available, whether a job is available, or other factors that don't relate to a person's individual needs. And I'm going to turn the rest over to Gina.
Thank you, Max. The agreement in Lane v. Brown has some provisions that relate specifically to education, and we wanted to run through those today as we see them as so important to the agreement. The Oregon Department of Education will be required under the proposed settlement to improve employment-focused transition services, and Oregon has agreed to allow the transition process to begin for students in transition with IDD as young as age 14 if deemed appropriate by an IEP team. Those students will be provided with just quite similar to the Rhode Island scenario that we discussed a few minutes ago. The students will be provided with information about and opportunities to experience supported employment services in integrated settings, and I want to note, while still in school, prior to school exit as part of the educational curriculum. The decree makes a point to prohibit schools from including sheltered workshops in the continuum of alternative placements and supplementary aids and services provided to students. And we should note that Oregon was a leader in including this in an Oregon administrative rule during the pendency of litigation. And the decree actually, confirms the parties' commitment to this rule that the use of shelter workshops is just not appropriate in Oregon as part of the continuum of alternative placements. The decree also excludes mock shelter workshop activities from school instructional curriculum. And we could advance the slide. The Lane v. Brown proposed settlement also accounts for provider capacity and technical assistance in training. Oregon, under the agreement, will maintain a technical assistance provider to offer high-quality training assistance and support to supported employment services agencies as they attempt to expand and broaden the array of services that they provide to people with intellectual and developmental disabilities in Oregon who are newly looking for employment. They also, under the decree, it recognizes grants for the transformation of existing shelter workshop providers, the development of new supported employment service providers, and the expansion of existing providers in order to ensure that the services are there for people who are looking for more integrated alternatives. Finally, Oregon DHS will take steps to affirm that the recommended standard for planning and implementing supported employment services is the opportunity to work at least 20 hours per week. They're going to do this in a number of ways, which include issuing guidance, utilizing outcome payment structures, and one-time-based performance incentives, seeking to promote the training of employment professionals around this new standard and job developers around the standard, and collecting data on the 20-hour standard. And now I'm going to turn it back over to Eve Hill for some concluding remarks from the Department of Justice.
Thank you. So over the past few years, the national dialogue around sheltered workshops has changed, not just at the Department of Justice, but across the federal government and across the country. The Innovation and Opportunity Act, passed in July 2014, requires states to set high expectations for competitive integrated employment for individuals with disabilities, including youth and individuals with significant disabilities. And consistent with the relief required in our agreements, the Workforce Innovation and Opportunities Act requires states to coordinate employment services, to assess current state skill levels, create individualized employment plans, and coordinate the provision of supported employment services, focusing on youth transitioning from school to work. WIOA also prohibits state and local educational agencies from contracting with sub-minimum wage programs and requires that youth go through a multi-step process before being permitted to work in a segregated setting. The CMS Home and Community-Based Service Settings Rule, issued in 2014, provides financial incentives to reimburse employment service providers when an individual secures a supported employment outcome of 20 hours per week or more, or earns a wage 20% above minimum wage, and other employment-related outcome milestones, incentives that are also consistent with the relief in the Department of Justice's agreements. Federal agencies have also been partnering through initiatives like the 11-agency Curb Cuts to the Middle Class initiative to focus consistently on middle-class jobs for people with disabilities. Some of those efforts were highlighted in a White House summit with employers, service providers, advocates, and philanthropy to increase employment opportunities for people with significant disabilities. And in turn, these efforts are leading to the reform of state systems where the rubber really hits the road. And if the suggestions of the Harris poll are right, as more people with IDD enter the integrated workforce, more people without disabilities will come to understand the truth about intellectual, developmental, and other disabilities, and the world will be changed for the better for all of us. So we look forward to continuing our work in this area and partnering with all of you, and we thank you for your participation in the webinar today. Back to Serena.
Fantastic. Thank you so much to our esteemed colleagues at the U.S. Department of Justice. Just really fantastic information. We did get a couple of questions, and I think we've got time for one or two of those, and then we'll reserve the remaining of them towards the end. There was a question early on about the average hours per week that people are working in integrated employment as a result of these settlements, and what these individuals are doing when they aren't at work during the day. And I know Oregon's settlement agreement is pretty fresh, so it would be hard to have that kind of data available. But do you have any information related to the implementation of the Rhode Island agreement, which is about a year old, or any thoughts about how the Oregon settlement will relate to this issue?
This is Gina Klein, and the Justice Department's decree with the state of Rhode Island incorporated both integrated employment and integrated day services. In fact, there were individuals that were unnecessarily segregated in day programs who were covered by that decree and who received access to both integrated employment and integrated day services. And we acknowledge that individuals with disabilities have individualized needs and choices and may work at different hours per week. But ultimately, they shouldn't have to choose between being engaged in employment for the number of hours that they prefer and being integrated. And so there is a broad array of services available under that decree because that case involved both segregation in shelter workshops and day programs. And as we mentioned on several slides, both the reach of Title II of the ADA covers segregation in day programs, but also the relief that was afforded under that decree provides for an array of integrated services that are not employment but are also inclusive of what people prefer and want to do during the day.
Excellent. We had several questions, I think, coming from states where there are long waiting lists for services in the community, and an interest in understanding really, how these landmark settlements impact states that still have long waiting lists and access to home and community-based services. Any thoughts about that?
If by waiting list what you mean is that there's a waiting list for Medicaid waiver services, at least the Oregon case probably doesn't directly impact that, although Oregon did not have a waiting list for Medicaid waiver services. But the claims and the settlement, I think even if they had been brought in a state with a waiting list, probably wouldn't have directly affected that. If by waiting list you mean that providers had waiting lists for supported employment services, which was certainly the case in Oregon, then yes, it had a direct impact on that, or we hope it will have a direct impact in that it would expand the ability of providers to provide supported employment services and lower those waiting lists. So there are provisions in our agreement that are designed to expand provider capacity. And some of those build upon and codify initiatives that were already going on in the state, and some of those expand those initiatives. The point was to make sure that there are more certified and qualified people out there in the community who can provide supported employment services, and the hope is that that will reduce provider-maintained waiting lists for those services.
Okay, great. Did anyone else want to add to that from the DOJ team? Okay.
No, we just want to thank you, Serena, for having us on.
Well, on behalf of ODEP, thank you. We're delighted that all of you could join us today. We will have several more questions for you and our other esteemed panelists, but we're going to move on to our second panelist today. For those of you that were following the earlier agendas, you might be expecting Ann Coffey, who is the Executive Director for the United Cerebral Palsy Association of Oregon and Southwest Washington, and has been a key catalyst in the initial legal action that was filed on behalf of clients through UCP in the state of Oregon. Unfortunately, Ann has caught a flu bug and could not make it today, but her outstanding colleague, Melissa Miller, who is an employment specialist and team leader at UCP of Oregon and Southwest Washington, has graciously agreed to step in for Ann. So thank you so much, Melissa. Melissa has been successfully connecting employers and job seekers since 2006 and moved into the employment field after closing her eco-friendly cleaning business 8 years ago. She has a master's degree in conflict resolution, and when she's not making job matches, she's probably training for a marathon or hiking with Gypsy, her border collie. So we love having Melissa on this and are really excited to hear the perspective of this particular organization who was really in the epicenter of the Lane versus Brown settlement. So turning it over to you, Melissa.
Yes, thank you so much. Again, my name is Melissa Miller, and I'm the program manager here at United Cerebral Palsy, and I've had the pleasure to walk in the footsteps and work in the shadows of all of those who helped United Cerebral Palsy take a leadership role in the employment field. Tara Asai and Bud Toon and Ann Coffey, who all helped close our sheltered workshop 18 years ago. So I'm pitch hitting for Ann. She worked very, very hard on this presentation, and I hope I can do it justice, so please bear with me. UCP was founded in 1955 by a group of parents and their children diagnosed with cerebral palsy. We're celebrating our 60th year of providing services. We have a variety of service areas. We serve children and adults in their homes. We do targeted case management by providing brokerage services. We have community inclusion services, family support services, and supported living services. Our mission is to increase the independence, productivity, and full citizenship of individuals experiencing intellectual and developmental disabilities. Our North Star is a community for everyone. We're proud of our heritage and the evolution of our service models over the years. It is a privilege to have this opportunity to share with you in greater detail some of the reasons why UCP decided to support the Lane v. Brown complaint as an organizational plaintiff. As I mentioned earlier, UCP has a history of transforming our models based on what our customers want, and we use the term customers or consumers instead of client here at UCP. And so one of our most significant initiatives was in 1989 when we successfully transformed our large 21-person orthopedic group homes into one of the first supported living model options in the state. The shift from group home to supported living was complex, but the success was rather immediate. Once an individual resides within the community, you have no choice but to figure it out, quote, end quote. So when it comes to supported employment, we closed our sheltered workshop in 1996, nearly 18 years ago, and shifted to supported employment. The shift was and still is quite a challenge. We faced many setbacks over the years and made many necessary adjustments along the way. We're still learning how to successfully deliver the service, how to successfully get people jobs in the community. We tried many different iterations of supported employment over the last decade. And over time, we learned that successful supported employment services are the combination of a variety of necessary ingredients. I know most of you know what those ingredients are. Like chemistry, if any of these necessary ingredients are altered, or if they don't receive the required attention, the recipe will fail. By 2006, at UCP, our customers, our leadership, and all of our employees were all in and ready for employment. It wasn't easy to navigate, but we knew how it worked by this time. And around the same time, state leaders began work on the adoption of an employment-first agenda. Oregon joined the Supported Employment Leadership Network, created a work plan, and a supported employment website. By 2008, the state established a policy for working-aged adults that was adopted as Oregon's Employment First policy. Over the next few years, from 2008 to 2012, UCP was excited to participate in early efforts to engage Oregon providers in the Employment First initiative. I won't go into detail, but many UCP leaders were at many tables participating in many meetings. On the surface, the flurry of activity should have translated into tangible outcomes like jobs and a system to support the desired outcomes to get people placed in employment. Memorandums of understanding were crafted, training and technical assistant entities were contracted, individual service planning was altered, grassroots employment first teams were formed, presentations and guidebooks were circulated, stakeholder meetings were facilitated, resources identified, grants, conferences, data was collected, the rate system was overhauled, strategic planning was initiative, the list goes on and on. Yet somehow, under the hood, a system to support the provision of quality employment services was more ineffective than before. By then, we were spending at UCP over 50% of our time navigating the system and sharing with state leaders what we thought needed to be done. This was time when we would have been better spent supporting job seekers. In our experience, the Employment First initiative just really didn't have teeth in those early years. Necessary policy decisions hadn't been made. No one had asked the following important questions. What is integrated employment? What about crews and enclaves? Are they integrated? What about minimum wage? How many hours should people work? Who pays for what and how much? And how do we track and monitor progress? In a nutshell, we were wondering, how was this rendition of Employment First any different than what occurred in Oregon in the 80s? Those initiatives didn't last. Although Oregon was speaking about the right thing to do, we were stuck in conversations that weren't going anywhere. Enrollment in non-workday services was continuing to rise at an alarming rate. In 2011, we were invited to a discussion with legal advocates about the state of employment services in Oregon. We shared what we knew. This eventually resulted in UCP being invited to take legal action against the state of Oregon. While we were deciding if we wanted to participate, we considered the past and what we knew about the immediate future. The state was experiencing a change in leadership. Some of supported employment's champions were leaving. Replacements were unknown or unexperienced in this area. Oregon was applying for a new and relatively untested home and community-based service waiver program, named the Community First Choice Option Plan. The federal match rate for allowable services would increase by 6%. Nobody within DD understood the impact to the DD system that would have. Oregon was also, at this time, learning about new HCBS rules and the potential impact to that service delivery system. Further, Fair Labor Standards Act changes were in play and would require attention and resources. Lots of big changes were coming, and we worried that supported employment would suffer. It had been 5 years since Employment First initiative had been launched, but there was still a great deal of work to do. In 2012, Lane v. Kitzhoffer, or Lane v. Brown, as it's now referred to, was filed, naming UCP an organizational plaintiff. In September of 2015, a proposed settlement was reached. It provides some of the teeth that were missing previous. For example, and as a result, there's a sense of immediacy now. There is greater attention and understanding about segregation and the importance of equal access to services. There are components that are enforceable. It reaffirms that this issue isn't going away and that rights rights violations are serious. The agreement serves to strengthen existing state policy and related planning documents. The executive order, the Integrated Employment Plan, Quality Assurance Plan, Capacity and Training, and Technical Assistance Plan, as well as the Awareness and Outreach Plans. It draws some lines in the sand on some really tough issues: wages, hours, integration, roles and responsibility, and transition age-related work. It also beefs up monitoring. There is an independent review process now. Also, Oregon will be collecting clearer data on what's working and what's not working. Further, it ensures a continued investment in training and technical assistance efforts. It supports ongoing funding and capacity development. It raised awareness among our legislators. It supports quality, person-centered employment planning. Most importantly, the settlement specifies jobs, not just access to services. To us, the result has been about access to jobs. Jobs matter, and jobs change lives. There is nothing more empowering than contributing to our community. There is nothing more powerful than a sense of belonging, value, and self-worth. And there is nothing more rewarding than getting that first paycheck. Thank you all for listening.
Thank you so much, Melissa. We really appreciate you being on the phone today and your perspective and that of your organizations who was so entrenched in what occurred in Oregon. I'm going to go straight into our third and final speaker because there's a lot of questions coming through that I think it would benefit having all panelists be able to jump in and address those. So last but certainly not least is our colleague and dear friend, Michael Maley, with Oregon Department of Human Services. Michael is no stranger to ODEP. He was the state's key liaison to us in our initial years when Oregon was one of our 3 original core states in the Employment First State Leadership Mentoring Program. And he has the affectionate nickname around here as the Employment First Czar because he, I believe, might be the first state official in the country who had employment first as part of his position title of his name. So we used to give him a hard time about being the first employment first czar at a state level. But Michael has been very dedicated and has spent his entire professional career working in Oregon service delivery systems for people with intellectual and developmental disabilities. He has served as the Deputy Director of the state's Office of Developmental Services and is now the Statewide Employment First Coordinator for DHS, or again, the Employment First Czar. We have had a very strong working relationship with Michael and his team in the past and are excited to hear his perspective on kind of the next steps as a result of Lane versus Brown. So, Mike, thank you also, Mike, for making the time to be here today. I know that you are multitasking and are at a national conference out of town, so we really appreciate you joining the call to provide the state's perspective. So just turning it over to you.
Well, thanks, Serena. Yeah, actually, I prefer Grand Poobah than Czar, but, you know. Let me, before I start, I think we have 15 minutes, is that right, that you've allocated here?
Yes.
Okay. But I feel after listening to the first couple of presentations, there's a couple of things I do want to say before I get into what I'd plan to say. You know, I'm not an attorney, and I can't speak to the kind of the legal issues that the attorneys brought up you know, prior to this. It was a kind of a long and drawn-out legal process, you know, hard fought. But I would say that I'm not sure that we as a state would agree with all the characterizations and some of the points that were made by both the attorneys and the UCP folks. So I just want to put that, you know, out there, you know, and just recognize that the settlement itself doesn't kind of admit liability or the state's violation of any laws. But having said that, I think the point here, and I think what you've asked us to do, is really talk a little bit about how we the work that we've done and where we intend to go from here. Because, you know, regardless of anything, really the question is, you know, what are our next steps and where do we go? You know, the settlement agreement is about a 30-page document that's fairly detailed, and so I would encourage, you know, it's hard to just kind of characterize generally, but I would encourage anybody who has access to that, and it's on various web pages, to read it in its entirety to kind of get the feel for it. But one thing I do you know, agree with in terms of some of the discussions is the settlement does talk about, the proposed settlement does talk about that we've made substantial progress, and in large part, you know, says to keep on doing, you know, what we plan on doing. And so that's really helpful, and we're happy to have reached a settlement, so we really know what the expectations are, and we can move forward. And quite frankly, it'd be helpful, to work on systems change without doing that, and also having to defend ourselves in a lawsuit, which just makes it much more difficult to do everything that needs to be done. So in terms of kind of the guts of my presentation, Serena, what I heard you ask is really what did we do to make some of the progress that we've made, and what do we intend to do in the future. So I thought I would hit that just briefly without a whole lot of detail. And for those of you listening, probably many of the things I will say is information that you've heard and probably in other webinars and seminars, perhaps just repackaged a little bit differently. But as we approached this a few years ago, we keep talking about systems change, and we were of the belief that there's an adjective in front of that, and that's sustainable systems change. The work is going to be long. I'm not sure there's ever a finish line with this, but it takes a while to make the kind of changes that everybody believes needs to be made. So we really felt like we needed to approach this in some sense of sustainability so we could keep momentum, and we felt like we would build a strong foundation that future changes could be built up on. And kind of within that sustainable concept, we had 5 or 6 things that we felt at a high level we needed to accomplish. One was that we had to make the conversation public. We had to create a buzz of some type about this initiative and what it was about. So making presentations to legislatures, discussing with key stakeholders, getting out in the various communities. That was an important part of the fundamental work that we wanted to get done. As Max was mentioning, I think in his discussion a little bit about the executive order, we felt like there are 3 key players mentioned in that: the Office of Developmental Disability Services, Vocational Rehabilitation, and the Department of Education. And we knew right off that we had to create a sense of joint ownership about outcomes, knowing that not any one party could do everything alone, that the impact of and actions of one agency impacted what happened on another, kind of that all dots were connected. So we knew we had to work hard at this kind of this we approach to getting the work and the outcomes done. We had to understand that systems change is, at least in the context that we were thinking about it, is two-dimensional. It's got a hard side and a soft side. There's certainly the policy and practice piece of that, but I think we're also engaged in changing belief systems. So we had to think of systems change in those 2 dimensions and work on both. Obviously, we needed to continue to build demand by working with younger individuals and their families in terms of education and awareness, because as people demand service, the system will be much more responsive. And we also believed we had to take kind of an organic approach. And we've talked about this in other forums, but the kind of change, the extensive change that we're talking about and sustainable change just can't be top down. It can't be just bottom up. It can't be right to left or left to right. We need to have a change working at all different levels and leaderships at all different levels, within our state. So those are the things we just thought about and talked about, as we were talking kind of this high level around systems change and this notion of sustainability. There were some key strategies then that we felt were necessary to deploy as we're getting kind of closer to the ground level. One was that we really needed to ensure that the highest levels of state leadership were involved in this. Certainly the governor's office issued the executive orders that are at play, but there was also a predominant role for the director of the Department of Human Services, where Vocational Rehabilitation and the Office of Developmental Disabilities sits, and the Deputy Superintendent for Public Instruction. So we had to certainly engage their support and leadership from those perspectives. The other thing that we did as we were looking closely at this was we really identified and framed the core functions that we had to plan and work on. And if you look at all the various plans that are out there and all the action plans and other kinds of plans, there's really just a finite set of areas you have to address. There's a million things you have to do in each of those, but there's only a finite set of things that you have, areas that you have to address. And the way that we defined those was data, quality assurance and improvement, communications, information and awareness, kind of policy and practice in terms of alignment and making sure that things were complementary, training, technical assistance, capacity building, and rate setting. So we organized our work around those themes. And again, as Max was talking about a little bit earlier, one of the things we did was put together what we call the Employment First team. And it's there's 6 of us, and each has assignments around those core functions that we're just talking about, and not only to take a lead in coordinating across the agencies how those core functions were playing out in terms of planning and implementation. The other part of it was to look at those core functions from kind of a balcony level, looking down and saying, how are we doing in those core functions as a unit, and creating information and perspectives from that. We also thought it was helpful, again, as Max mentioned, that this office be placed under the department or the director of the Department of Human Services, so it wasn't embedded in any particular program site agency. So there's a little bit of an arm's length, as we did our work. The other thing that we did, again, around this notion of a common responsibility, common outcome, and deploying those core functions, is we took a project management approach. So we developed an implementation, plan that crossed all of those agencies, where everybody knew, what their roles and responsibilities were across agency to meet some common outcomes or some common achievements. And we really looked at how that was done, not only in planning, but in monitoring how we all were doing in making that happen. We put together a weekly steering committee where the leaders of the program offices, where we meet weekly to talk about how we, again, are doing. The other advantage of doing that is not just in terms of the implementation of a common work plan toward common outcomes. It also gives us a chance to look at how we're going to address all of those competing interests that are at play. And for those of you who work in federal or state government, there's always other things to do. So there's always some level of competing interest or competing priorities that have to be worked out. So we created a forum for that happening. The other key strategy, or another key strategy we did, was we sought feedback. We knew that this was going to be an ongoing learning and adjustment from what we were learning, what we did wrong, what we did right. So we had to make sure that this was a kind of a dynamic implementation process. So that involved getting feedback from lots of different people, subject matter experts and others, to say, what are we doing right, what are we doing wrong? Sometimes we agreed with that kind of feedback, sometimes we didn't. Sometimes we could implement what the feedback was, sometimes we couldn't. But there's this dynamic that you've got to put in place, this learning dynamic. And just to give ODEP its props, if you look at virtually all of the things that we've done in these core areas, the ODEP's fingerprints are on that, because that was a very helpful early engagement process as a core state that really helped frame some of these sets of activities that we needed to do. This next key strategy that we did may sound a little silly on its surface, but I'll tell you it was hugely impactful, is that one of the things that we had committed to do was have the leadership of the various agencies show up at the same place at the same time, whether it was a presentation, whether it was a work group of some type, whether it was a community forum. You know, it was important to have all those agencies, the leadership from all those different partners there at the same spot, talking about the same set of activities and the same desired outcomes. And that has proven to be really a very just powerful strategy that we deployed, and it's still true today as when, and actually this morning we did the same thing at the conference where I'm attending. That had a really powerful impact on moving things forward. And then the other piece was, and I think this is something that Max mentioned, we adopted outcome measures and metrics, made those public, and the data around those we made public as well. So that also helped in the public discussion about how well we're doing and how well or where areas we need to adjust on. So those were some of the key kind of more ground level strategies that we put into place and will continue to build our future efforts around. If I were looking at some of the highlights of our implementation efforts so far, and again, I know this is, so many people out there have heard this, but the use of success stories has just been so powerful, and we put out weekly messages. Many of those are around success stories, and when we write those stories, we really try to talk about how it was a combination of efforts by a number of folks, that kind of we involvement that led to the success of that job. We set up and are supporting local employment first leadership teams around the state, and there are more of them being developed all the time, where local communities are getting local partners together and talking about how the employment first agenda can work at that local level. And that's part of that kind of organic piece that I was trying to talk about earlier. The other thing another strategy that we used that's proving to be really effective is through the initial executive order, there was an expectation that there be a transition network established around education. And one of the things the Department of Education did was fund 8 part-time, what are called transition network facilitators that are regionally stationed throughout Oregon, to really facilitate what's happening locally in terms of schools and adult services working together to make sure that transition is happening more effectively. And recently, these were half-time positions, but recently the VR, our Vocational Rehabilitation Program, actually added money to those positions so they could become full-time, and they are kind of a joint VR ODE-funded strategy where there's really some local representation to help facilitate moving the agenda forward. And we have done a lot of things around capacity building, a lot of training around core competencies that we established that relate to the whole APSE core competencies that are developed out there. And just FYI, Oregon now has more certified employment support specialists that APSE does, the CESP APSE designation, in any state, and we were the first one to break 100. So we're kind of leading the nation in the CESP APSE certified folks, and we're doing a lot of work in provider transformation, and we have some seamless transition pilots going on around the state, and those will continue as well. So I imagine I'm kind of running out of time here, but there's just other things we've got to do. But I think the future for us is a couple of things. One, we got to keep our partnerships and coalitions strong. We've got to expand those and make sure that they are well established at the state and the local levels. We've got to continue kind of to give Linda Rolfe some recognition. You know, she's always talked about you need to win hearts and minds, and we still have to continue the information and awareness efforts to show people that that work can be part of their personal long-term vision for themselves. And we've got to figure out how to continue to implement WIOA and the CMS integration standards. So the settlement is one piece. Our overall work with Employment First is another piece, but the other pieces that we have to incorporate in all of our work is WIOA and the CMS integration standards. So, so the settlement for us, the proposed settlement, isn't an end of anything. It's the beginning of a whole bunch of stuff, and that's what we plan to continue to work on. So, Serena, that's it.
Great. Thank you so much, Mike, again, for being here today. We had several questions, and I think we've got time for 2 or 3. One question we received multiple times, so I want to give our colleagues at DOJ an opportunity to reaffirm and reinforce a point that was in their presentation around informed choice. There are several questions about if an individual really wants to stay in a segregated setting, what are the requirements there on behalf of the provider. And I noted that in slide 22, you have a bullet around ensuring informed choice with fidelity, in that individuals with IDD may remain in segregated programs if they request a variance after they have received a vocational assessment, a trial work experience, outreach information, and benefits counseling. Do you all want to expand on that a little bit, though? Because I think we had a lot of folks querying about that.
Sure, Serena. This is Gina Klein. I think that the Justice Department understands what a lot of people understand, which is that if any of us spent a protracted period of time outside of the competitive workplace, it would be very difficult to make an informed choice about whether we wanted to rejoin the competitive labor market. And so we too believe that our work reflects the idea of informed choice, and we have provided for an organized process in our agreements and in our understanding with states about how individuals with disabilities, and in these instances, individuals with intellectual disabilities, would be presented with the type of information and, more importantly, the type of experiences necessary to really make a meaningful and informed choice about whether they do not want to access competitive workplaces. In the Rhode Island decree, there is an affirmative requirement that individuals receive all of those things that you just listed, the vocational assessment, a trial work experience, outreach, in-reach education, benefits counseling, to decide. If you don't know how income impacts your ability to work and your public benefits, you might not be able to make the decision. So we understand that. The state of Oregon has taken steps to develop its own organized process by which individuals can choose to remain in a segregated setting. I believe they call it the decision not to explore employment as part of their individual service planning process, and Mr. Maley would know more about that than I would, but in general, the system exists to serve the individualized needs of people and to reflect that employment should include a meaningful choice whether to participate in integrated settings or not.
Great. Mike, did you want to add something from Oregon's perspective on that?
Yeah, I think that generally that's right. We're engaging in at least an annual career development planning process, and that's intended to be, the forum. It's tied to the individual support plan, and that's intended to be the forum where you can have that discussion about employment and people's future, and have those discussions that help people make an informed decision, and or the kind of other activities that could help people lead to an informed decision. And if somebody chooses not to, that's not the end of the conversation. That is brought up again and again, so so people can change their mind and get more information about making a more positive decision.
Great, thank you. I have one final question, and that is from Melissa, because we talked, and you touched on this a little bit, Regina, in your comments just a moment ago, but I think a lot, we are, you know, the $8 gazillion question around asset and income limits to that deter and disincentivize work for people who are desperately needing long-term supports and services to remain in the community is still a big issue that we're all trying to tackle at a federal and state level. But I'd be curious, Melissa, to know at UCP how you all engage in benefits planning discussions and how you approach families and individuals about income generation and how that might impact their benefits, and strategize with them in a way that makes work possible, practical, and exciting.
Yes, that's an excellent question. It's definitely a process that we take one person at a time. Everyone with their own financial advisors, their support people, their loved ones, their caregivers, they're going to have different goals and strategies. Some of the consumers we serve do aim to reduce their reliance on government funds, and we can assist them by coming up with a plan, a long-term strategy for getting off of Social Security and Medicaid. Others want to remain on Medicaid so that they can keep their medical benefits and are less concerned about the financial benefits of Social Security. So we can work with them also to come up with a plan for making as much money as possible. There are a variety of different incentives, such as PASS plans, Plan for Achieving Self-Sufficiency, which are unfortunately overwhelmingly underutilized. There are some other incentives provided by the federal government, work incentives and work incentive programs. I will say that Michael Walling, we've gotten a lot of training from Michael Walling. He has a wonderful website. He travels around the United States and teaches people that you can make tens of thousands of dollars a year. I think he says $34,000 a year, and still keep most of your Medicaid benefits. So there are tricks to the trade, and most importantly, though, it is about educating and getting benefits counseling and doing planning so that the earnings are planned full and we can protect our consumers and maintain the services that they need.
Melissa, that was an excellent response. I really appreciate it. We are at our time, so I want to turn over to the Lead Center folks, but I do want to thank everyone for joining us, all of our esteemed panelists, but also our participants. I know many of you are neck deep in your state or local systems change efforts to increase competitive integrated employment options for people with disabilities and at the same time do no harm. We fully encourage all of you to join our National Employment First Community of Practice. You can get details about that on ODEP's Employment First webpage or at the National Lead Center, where we have tons of resources on provider transformation, capacity building, and really how to align practice, funding, and policy to support our common goals in this area. So thank you again so much to our terrific panelists. This was very informative, and we really appreciate your time. I'll turn it over now to Rebecca for some final comments, and we'll close the webinar.
Thank you so much, Serena. And yes, I want to thank Serena for moderating this panel and for all the wonderful information. Our thanks to the team from the Department of Justice and from the state of Oregon. This was just such a useful set of information for people who work in the field and who are struggling with many of the same issues, and you provided a lot of information that I think people will be able to use. On this last slide here, we do provide you with lots of ways to access the information. The transcript for this, as well as the slides and a recording, will be on the Lead Center website next week. So we encourage you to share the link to this information with colleagues who may not have been able to participate. And thank you all for joining us today. Bye.